If a plaintiff sues multiple defendants, settles with some, then goes to trial against the others, how are damages allocated? The United States Supreme Court considered that question in McDermott Incorporated versus Amclyde and Riverdon Castings Limited. McDermott bought a large ocean-going crane from Amclyde equipped with a main hook manufactured by Riverdon and supporting steel slings manufactured by companies identified as the sling defendants. McDermott first used the crane to move an oil platform deck from a barge onto its base attached to the floor of the Gulf of Mexico, but a prong of the main hook broke, damaging the deck and the crane. In an admiralty action, McDermott sued Amclyde, Riverdon, and the sling defendants. McDermott settled with the sling defendants for $1 million. At trial, McDermott accepted responsibility for any part the slings played in the accident. The jury found that McDermott suffered $2.1 million in damages and allocated the liability thus: 32% to Amclyde, 38% to Riverdon, and 30% to McDermott and the sling defendants. The district court denied Amclyde and Riverdon's motion to reduce the judgment pro tanto by the $1 million settlement. Instead, the court multiplied the total damages by the percentages of liability and entered judgment against Amclyde for $672,000 and against Riverdon for $798,000. The court approved this allocation, even though, added to the $1 million sling defendant settlement, the sum exceeded McDermott's damages. The Fifth Circuit reversed. First, it held that a contract provision precluded any recovery against Amclyde. Then the court reduced the total damages by the 30% attributable to McDermott and the sling defendants, leaving total damages of $1,470,000. It then deducted the $1 million settlement. Because the remaining $470,000 was less than the jury assessed against Riverdon, the Fifth Circuit awarded judgment against Riverdon for $470,000. The United States Supreme Court granted cert.